Pass over this.
One case not restored CMP 1/2022. I could find from the recording of the notices were issued in the limitation matter as well as in the substitution matter. But that substitution petition could not be disclosed. As per
सर्विस कंप्लीट है ना, तो सब्स्टिट्यूशन अलाउ कर देते हैं।
दोनों मैटर में दिया था नोटिस बाय ऑर्डर डेटेड 9/1/2025।
एक कॉम्बिनेशन ऑफ डीले है
तो अलाउ हुआ
वो अलाउ
6339 6339 of 2025 that is to be disclosed।
ओके, ये 6339 ऑफ 2025 को जो है
for substitution for setting aside abatement and limitation that is the notices were issued to the proposed legal rates।
they died during the pendency of the
second।
ये आइए विनीत जी को बोलेंगे अलाउ कर देंगे। नोटिस सर्विस कंप्लीट।
yes so this is the office note shows ना
ठीक है,
ये लॉसिंग recorded that
और छूट गया होगा ठीक
है हमसे नहीं छूट गया।
6339 of 25 in CAP number 120 of 2022 इसको अलाउ करना।
very sorry।
वैसे हम लोग करेक्शन करते समय ये सब हमारे स्टेनोग्राफर सब चेक कर लेते हैं, लेकिन कभी छूट जाएगा तो दिक्कत होती है।
एक सीएफटी का ऑर्डर से सर अनुरोध कोर्ट के पास तो अलाउ हो गया। अब आगे देखते हैं कि किसी मरे हुए थे
ये वो
तो सीएमपी 5 के मुझे पॉइंट आउट
नहीं सीएमपी में अगर कोई पार्टी डेड है ना तो बहुत दिक्कत है।
Pass over case item 21 CNT 898 of 2024।
He will put लिया। When did he come? He has any objection?
He told me on phone that I have no objection. I will oppose in merit. But let him come. He will say so.
It's better क्योंकि डिले आपका काफी है ना।
जी भैया
डिले बहुत ज्यादा है, उनको बिना सुने ऑर्डर।
हाँ जी जी
नेक्स्ट वीक पोस्ट ऑन नेक्स्ट वीक। देखिएगा petitioner present, nobody appears on behalf of the opposite party।
Item 32 contempt civil 745 of 2024।
State that है
communicated by Secretary 29/2026 that contract employed by Shopos dated 4/2/26.
it has been communicated to the university।
It has been communicated. The fixation has been done on 29th of January. So we request some more time, 4 weeks time. In the meantime, we file the compliance.
Compliance means you will
Payment to the
credit।
payment.
The contempt civil 745 of 2025। A show cause has been filed on behalf of opposite party number 2 annexing the letter number 234 dated 29/1/2026. The learned counsel for the state has submitted that the needful has been done on behalf of the state। Counsel for the university submits that the matter be placed after 4 weeks. In the meantime, compliance report indicating the payment of admissible amount to the petitioner will be filed। Post on 13th March. The compliance report will be filed by 11th of March। Appearance.
Item 37 contempt civil 1402 of 2025।
Yes, please. Are you there, Mr. Mehta? Compliance नहीं हुआ? हो गया।
contempt
Let us Yes,
Interest on credit.
interest and interest on gratuity. ये 34 lakhs का पेमेंट हुआ है.
The only thing that was left behind was interest on salary,
Yes.
unpaid salary. That was the direction passed by the lordship in the main petition. That we have already paid.
You see, just a moment. You see annexure B.
Annexure B. Yes.
This is gratuity amount is 20 lakhs.
Yes, yes.
इस पर कोई इंटरेस्ट
तो
नहीं
इस पे
है.
इंटरेस्ट का कोई और
इस पे तो कोई
नहीं,
और
नहीं। इंटरेस्ट ऑन सैलरी का और था which we had not paid.
gratuity तो this amount is inclusive of
Yes.
all interest.
No, gratuity amount this is payable. We have paid. There was no such plan in the
No such direction.
No such direction. And
You see, if there is any statutory interest, suppose if there is any statutory interest which remains payable, I'll keep your right intact. You can just take steps as per law. But in the writ petition, there is no such direction. Okay? Thank you. Contempt Civil 1402 of 2023. The learned counsel for the opposite party has submitted that order has been complied. To this, the learned counsel for the petitioner has submitted that the statutory interest on gratuity has not been paid to the petitioner. Considering the nature of order, this court is not inclined to proceed any further in this contempt proceedings. However, if there is any statutory interest payable, it will be open to the petitioner to take steps as per law. Right? This contempt proceedings is here.
Item 22, election petition 7 of 2025.
The issue has been raised with regards to the maintainability of this election petition under Order 14 Rule 2 of the CPC.
Yes.
I filed the rejoinder to it, and the opposite party have also filed a reply to my rejoinder. Now, as far as the maintainability issue is concerned, it was framed by the Honorable for the last occasion, that is not my point. But again, if they have raised, so only 2 points they are raising, that is at para 5, para 4 of the IA. They have raised 2 issues. One is whether the present application is maintainable in the present form.
Para 2 of the IA.
Para 4 of the IA. Dear IA.
Para 4, yes.
Yes. The first one is whether the present application is maintainable in the present form. The second one is whether this application is barred by the principle of limitation and bail form. Now in para 5 they are pressing only the issue number 1, which is with respect to the maintainability of present petition in the present form. Now, as far as I understand, the present form is the format and the requisite, whatever the essentials are there for the filing of the present election petition, as far as the Representation of People Act and the Jharkhand High Court rules. Moreover, if we go to the limitation part also, that is also there in section 81 of the Representation of People Act. Now my submission is
Section
that
81 provides for condonation of delay.
no, but I have filed within the limitation prescribed the 45 days. I filed it within that limitation.
Has it been filed within 45 days?
Sir, that we are not pressing at the present, my lord.
IA not pressing?
No, no, we are pressing one thing, my lord, that my lord will come to page paragraph 9 of the IA. That was also in the initial objection also. We have made an objection in the maintainability through this only, because there is a recent judgment of the Honorable Apex Court, my lord, where this issue has been decided and settled forever. My lord, we just come to paragraph 9 of the IA, at page 8.
Yes.
there we have stated, my lord, that as that
This is on merits, no?
on the materiality, my lord, because the honorable apex court, my lord, will see the judgment.
You see, the election petition has been filed,
Well,
challenging the election. That is a challenge.
well,
So these nomination and these things, how are they
that is
relevant?
the issue, my lord. They have
That will be
said
the main issue. We will
that
decide
is the
it.
main issue.
We will
because
decide it. The documents are required to be exhibited. We have to see what is
That's
the.
why, my lord, I was drawing my lord's kind attention to your apex court judgment. It says, my lord, these issues are minor in nature, does not affect the.
That we will see at the final stage.
And for that, my lord,
You
for
see.
that, my lord, because they have said only few things, my lord, in their.
No, whatever be it, we will not enter into the merit. This cannot be decided as a preliminary issue. Preliminary issue is that it is absolutely ex speciae barred by limitation, or there is no provision for condonation of delay. It is something, preliminary issue. It can't be decided under
The issue,
order.
my lord, what they have raised in their initial petition, my lord, that there is something wrong in the mentioning about the car. One car was not mentioned, one education, one land.
That is on.
This-
That is on merits.
This is the apex court says, my lord, in
That is
2005
on merits.
judgment,
You
my lord.
see.
This is not required to be gone into the merit and long hearing is not required.
No hearing. आप बताइए ना day to day करते हैं. आप यहाँ पे कहाँ से यहाँ से सब day to day. आप बताइए आपको जब मानो करिए. आप ही टाइम लेके भागते रहिएगा.
ऑर्डर 14 में एक मिनी ट्रायल हो जाएगा इस पॉइंट ऑफ टाइम.
नहीं ऐसा नहीं करेंगे. ऐसा नहीं करेंगे और हम अभी तक कोई भी इलेक्शन पिटीशन नहीं डिसाइड किए. So I want to decide it. और इससे पहले डिसाइड करेंगे कि आपका टर्म खत्म होने के पहले. है ना? तभी ना पर्पस है, नहीं तो क्या पर्पस है?
आपको क्या
तो बताइए. इसमें आइए का क्या ही मतलब है, ये सब का रेलेवेंस नहीं.
आईए में जो पॉइंट्स लिए हैं वही रिटन स्टेटमेंट में लिया
वो आपका ऑब्जेक्शन
और उसके बाद ही इश्यूज फ्रेम हुआ था लास्ट.
कोई सिर्फ इतना बोल देते हैं these matters to be considered at the time of final disposal. Issues have already been filled. That should be sufficient.
That is the
IA number 660 of 2026 and election petition number 7 of 2025. This petition has been filed under Order 14 Rule 2 with bracket 2, read with Section 151 of CPC, to treat the maintainability of the election petition as a preliminary issue. And for that purpose, the following 2 points have been raised. Roman 1, whether the present application is maintainable in the present form. Roman 2, whether the application is barred by the principle of limitation and waiver. The learned counsel for the appellant, for the petitioner, submits that the petition has been filed within the period of limitation, and therefore there is no question of the petition being barred under limitation. So far as the point regarding maintainability in the present form is concerned, he submits that the petition has been filed as per the prescribed form, and no defect as such has been pointed out by the respondent with regard to the manner in which the petition has been filed. The learned counsel for the respondent has submitted that, has referred to paragraph 11 of the interlocutory application, to submit that allegation has been levelled regarding non-disclosure of inconsequential matters, and therefore no useful purpose will be served by long-drawn adjudication of the matter. In response, the counsel for the petition, he has also submitted that so far as point regarding limitation and waiver is concerned, he is not pressing the same at this stage. To this, the learned counsel for the petitioner has submitted that the disclosure where the non-disclosure where inconsequential or material where is or substantial is required to be considered through evidence, and therefore the election petition cannot be rejected on preliminary issue. After hearing the learned counsel for the parties and considering their aforesaid submissions, this court is of the view that the points raised through preliminary issue requires appreciation of evidence and materials to be placed by the respective parties, and accordingly this IA is hereby rejected. अब क्या करना है? नेक्स्ट स्टेप 2 बताइए क्या करना है आपको? प्लेंट आ गया, रिटन स्टेटमेंट आ गया,
सब आगे
अब क्या करना? अब आपको क्या करना है? प्रोसीजर बताइए, आप ही बताइए, हम तो कभी नहीं किए इलेक्शन पिटीशन. टेल मी व्हाट प्रोसीजर इज टू बी.
रिप्रेजेंटेशन की करेक्ट दिया है फाइल इलेक्शन पिटीशन.
हाँ.
इसमें आई थिंक एग्जामिनेशन ऑफ पार्टीज भी होना.
आपका डॉक्यूमेंट सब फाइल हो गया?
हां, प्लीडिंग्स कंप्लीट.
नहीं, प्लीडिंग्स नहीं,
Petition.
प्लीडिंग्स तो प्लेंट एंड रिटन स्टेटमेंट होता है.
हां,
उसके अलावा डॉक्यूमेंट्स वगैरह
लिस्ट ऑफ डॉक्यूमेंट्स.
लिस्ट ऑफ डॉक्यूमेंट्स आप फाइल किए हैं?
नहीं वो नहीं.
आपने फाइल किया. आप लिस्ट ऑफ डॉक्यूमेंट्स तो पहले फाइल होगा ना?
इनको पहले फाइल करना चाहिए, किस डॉक्यूमेंट पे रिलाई करना.
एनेक्शर 6 इसमें तो एनेक्शर करके बाल लगा हुआ है सब.
हां, उसमें तो लगा.
यही डॉक्यूमेंट्स है क्या? इसके अलावा भी कोई
इसके अलावा
डॉक्यूमेंट्स?
कुछ इसके बाहर का डॉक्यूमेंट नहीं है.
तो बताइए नेक्स्ट स्टेप पे क्या होगा? गवाही, लिस्ट ऑफ विटनेसेस प्रोड्यूस करिए.
लिस्ट ऑफ विटनेस
हम फाइल कर देते हैं. लिस्ट ऑफ विटनेस को हम बन जाएगा.
आप भी फाइल कर दीजिए. Both the councils undertake to file list of witnesses by next week.
At least 2 weeks time.
आपकी को टाइम चाहिए. At the request of the counsel for the petitioner, counsel for the parties post on 20 फरवरी. लिस्ट ऑफ विटनेसेस में सबका अवेलेबिलिटी भी बताएंगे. इलेक्शन पिटीशन है ना, कौन कब कहाँ बिजी है, कब कौन अवेलेबल रहेगा.
there is some problem, personal problem. Any date after 20, it will be on 27th.
19th
27
19th को आप अपना लिस्ट ऑफ विटनेसेस बता दीजिए और एक टाइमलाइन.
There is a marriage in there. On that particular week.
13 तारीख लिस्ट ऑफ विटनेसेस.
13 मार्च.
नहीं 13 मार्च का
मार्च
हो
है.
गया.
थोड़ा सा जल्दी हो जाएगा.
मतलब आप बताइए, पिटिशनर को कोई इंटरेस्ट ही नहीं है केस में, क्यों फाइल कर दी है?
24-25 कभी रखेंगे.
क्योंकि वो अवेलेबल होने चाहिए. हमको बात करना होगा कि आके बस वोट कर दें और इशू नहीं होती. दिन बन जाएगा.
लिस्ट ऑफ विटनेसेस में ओथ का
वो मैं
जरूरत
उनका अवेलेबिलिटी पता कर दीजिए.
नहीं. लिस्ट ऑफ विटनेसेस में ओथ का क्या जरूरत है?
वो का कलर
ऑन रिकॉर्ड नहीं करना है.
नहीं वो तो ऐसे ही फाइल.
ऐसे ही लिस्ट ऑफ विटनेसेस तो ऐसे ही फाइल होता है.
13 I thought it has to be filed as a document on record. Well, then you give it already.
ऐसा तो नहीं
ऐसा
होता.
कुछ नहीं.
आई डोंट थिंक सो. ऐसा होता है क्या?
नहीं कर लिस्ट ऑफ विटनेस कर देना है कि
हाँ.
जो आपके तरफ
अंडर योर सिग्नेचर उनका डिटेल्स दे देंगे, उनका पेरेंटेज दे देंगे, उनका एड्रेस दे देंगे और एक इंस्ट्रक्शन ले लेंगे कि कब से गवाही देंगे वो.
ठीक है, वो तो फिर
पोस्ट ऑन करती है. आप भी अपना लिस्ट ऑफ विटनेसेस दीजिए.
Item 23.
ये सुप्रिया शर्मा कौन है? एडवोकेट है सुप्रिया शर्मा. some request was sent. Huh?
From the side of respondent.
From the side of respondent. Supriya Sharma.
Perhaps I think she might be very permission of India क्योंकि उसके लिए पहले वगैरह कई किए हैं.
The appeal में कोई बात. Yes, ma'am.
Hello.
Are you
Yes,
appearing
ma'am.
for somebody?
मुझे
Are you appearing for somebody in this case?
Permission of India is not a party.
It's not a party. Are you appearing in this case?
yes,
Whom are you representing?
ma'am.
Whom are you representing?
I'm from the respondent side and I am observing the matter.
Okay.
Ma'am, I am from the respondent side, from the Mayank Parva side, advocate Mayank Parva,
Okay.
and I am observing the matter.
Okay, no problem.
Okay, ma'am. Thank you.
Appearance. Item 23, civil review 118 of 2025.
IN number 1 and 1 for substitution.
Who has expired?
Opposite partner,
When?
on 2/6/25.
After the judgment or prior to the judgment?
After
Notice has been issued. IE number 144 of 2026. In civil review number 118 of 2025. The counsel for the petitioner has submitted that the sole opposite party has expired on 2/6/2025. The names of legal heirs and successors have been mentioned in paragraph 7 of the interrogatory application. And the address has been mentioned in paragraph 8. Issue notice to the proposed legal heirs and successors of the sole opposite party for which requisite under speed post and also ordinary process be filed within 2 weeks only. In the idea and also in the main petition. दोनों में फाइल. Is there any petition for condonation of delay also? तीनों में तीसरा 2 आइए, ठीक है, आइए नंबर 12617, the main petition and also बस 2 आइए and main petition, correct? Next date, I've given you 2 weeks time, no? Was on 26th March. The decree has been executed. What is the position? There was a, I think, specific performance judgment. What happened ultimately? The specific performance decree has been set aside. You know, next one.
Item 24, CRNP 3610/2025.
CRNP number 3610 of 25. at the request of the council for the. Why are you seeking time? Post this case on next Friday.
Item 25, First Appeal 1 of 2026.
Limitation 196.
Four, five.
4586.
और कोई आइए पेंडिंग नहीं है ना? How much is the delay?
196.
DTIA number 4587 in FA number 1 of 2026. Counsel for the petitioner is present. Nobody appears on behalf of the respondents. The petition, the interlocutory application has been filed for condonation of delay of 196 days. The learned counsel for the appellant has submitted that, has referred to paragraph 6 of the interlocutory application and has submitted that the reasons for delay are bona fide. He has also submitted that the matter relates to compensation regarding land acquisition. No counter affidavit has been filed to the interlocutory application. However, being satisfied with the cause shown, the IA number 4587 of 25 seeking condonation of delay is hereby allowed. Admit, call for records from the concerned court. Since nobody is appearing on behalf of the respondent state, let a copy of this order be communicated to the learned advocate general to ensure appearance of the counsel on the next date. A special messenger cost जमा करें. Special messenger cost. Special messenger cost. Upon deposit of special messenger cost by the appellant within a period of 1 week. Post on 26th March. Let this order be communicated back to the concerned.
Item 26, First Appeal 2 of 2026.
Same thing. Sorry. How much is the delay?
175.
Are you serious about condemnation?
The documents that have been provided are post the time limit that is my objection.
IA number 16721 of 25 in FA number 936 of 2025. No, FA number 2 of 2026. Okay. Sorry, IA number 4584. Sorry. IA number 4584 of 2025. This petition has been filed for condonation of delay of 175 days. The counsel for the appellant has referred to the statements in paragraph 6 and 7 of the interrogatory application. Submit that there was certain medical condition due to which appropriate steps could not be taken. The learned counsel for the respondents has opposed the prayer and has submitted that the documents filed along with the interrogatory application are inter alia relating to the period 24-25. October is of October 2024, December 24, January 25, and the same cannot be considered for considering sufficient cause. Award is dated 10/5/2024. After hearing the learned counsel for the parties, and considering the facts and circumstances of this case, there is no doubt that the documents, the medical documents placed on record are little after the period after the expiry of period of limitation. But considering the fact that the matter arises out of land acquisition, and certainly there are medical reasons thereafter, at least right from 14/10/2024, this court is inclined to condone the delay in filing the first appeal. Accordingly, IA number 4584 of 25 is hereby allowed. Admit call for NCR upon deposit of special messenger post. Okay. Since the record same है, since the records have already been called for in the connected case, therefore the same will suffice for the purpose of the present case also. Okay, now एडमिट तो करनी है, उसमें कौन सा डेट दिए हैं? 26/3 का डेट है ना उसमें, 26/3 का डेट है उसमें. Let this case be tagged along with FA number 1 of 26. Correct? Next. क्या होगा 25 में? सेम मतलब? अच्छा ये बात आप नहीं अपेयर कर रहे थे, आप ये बात बोलिए आप अपेयर कर रहे हैं.
Item 27, CLP 76 of 2026.
IBM number 11/21/26 of condemnation of it. And signed with 26/26, which is the last 50 days.
ले आओ.
50 days.
कोई बात नहीं, आप मेरिट पे बहस करिए. मेरिट पे बहस करिए. अच्छा ये CMP है.
CMP.
आप क्यों आपका केस डिसमिस हो गया?
और वन क्वेश्चन नंबर एक्चुअली उसमें रेस्पोंडेंट नंबर 2 को लीगल एस्पेक्ट टू इसका पेनल्टी टाइम दिया गया था. हमने फाइल कर दिया, लेकिन ये सेकंड अपील जो है सेम जजमेंट से एक है 522 जो प्रेजेंट है, फाइल 521 ड्यू टू लेटेस्ट इन पार्ट ऑफ द फाइलिंग हाई कोर्ट फाइल देन इज द टू ऑफ द CMP वन ऑफ द CMP गलती से उसमें फाइल.
पर हम लोग क्या करें, आपका तो प्रोसीडिंग ही अवेट कर दिया.
फिर नहीं अदर्स में उधर गया तो कहा कि नहीं बहसी किया जाए, तो चूंकि नॉट टेकन इंस्ट्रक्शन यार बट राइट ऑफ सू क्लासेस इवेंचुअली अदर्स as your point I see and simply fine, एक program लेकिन वही दो प्रोसेस ये आपको प्रोसेस
तो दूसरे केस में भी तो ऑर्डर हुआ होगा नोटिस का
ना, उसमें ही इसका नहीं.
तो केस नंबर गलत में फाइल कर दिए क्या?
हाँ सेम जजमेंट दोनों में आए थे. सेकंड में 521 और 522 का आदेश का पेनल्टी 257 का लीगल एयर्स का नोटिस.
और 521 में 521 में ऑर्डर नहीं था.
नहीं उसमें नहीं इसी में
टाइटल सूट है 73 का, हम इस तरह से नहीं रेस्ट होते. क्या चीज समय देंगे? आधे लोग मर ही गए होंगे अब तक. आई डोंट नो. 73 का टाइटल सूट, 91 का सेकंड अपील. अब अगला सेंचुरी में करिएगा. 21,001 क्या चीज का हम आपको समय देंगे, आप ही बताइए. अभी तो नोटिस सर्व होने में 1 साल लग जाएगा. आपको क्या लग रहा है? हाँ, केस आप इस तरह से इतना मिसहैंडल करिएगा, नोटिस सर्व होने में 1 साल लग जाएगा. एक महीना में हो जाएगा. अच्छा, एक्स पार्टी हम डिसाइड करेंगे. आपका रेस्टोरेशन 73 का सूट. मौका तो आपको बहुत दिया था. 1991 से पटना से ये केस आया हुआ है. हम लोग के सिस्टम में शो कर रहा है पेंडिंग चल रहा है. हम लोग को शोभा नहीं दे रहा, आपको शोभा दे रहा है, कोई दिक्कत नहीं. हम लोगों को नहीं शोभा दे रहा है,
Certainly.
ठीक है।
Right.
97 का अपील को लेकर, 73 का सूट को
Yes,
लेकर
sir, yes, होगा, आएगा, बिल्कुल।
कुछ नहीं। रेस्टोर तो अगर अभी तक को नोटिस भी करने का मन नहीं कर रहा आपके से, क्यों करें हम आपका ये 15 दिन का नोटिस? व्हाई शुड आई? थोड़ा हमारे ऊपर भी मर्सी करिए कि ये पेंडेंसी हम लोग को अच्छा नहीं लग रहा है। क्या था पार्टी, ये क्या था? पार्टीशन सूट था क्या था? फाइव 21 का में जो आप फाइल किए वो कहाँ दिख रहा है आपको, बताइए कहाँ फाइल किया? 5 एट पेज
CMT
हाँ CMT का बताइए कहाँ पर है?
15 पेज
पेज 15 में क्या है?
फाइल किए हैं, कई 60 को फाइल किए हैं और वो प्रोसेस फाइल किए हैं और उसका 16 पेज पर देखिए 15 साल पे ऑर्डर्स करते हैं आज ऑर्डर्स पास लगभग 6 साल के
डिस्पोजल केस में फाइलिंग लेता है क्या? यस, डिस्पोजल केस में फाइलिंग लेता है? डिस्पोजल केस में फाइलिंग नहीं लेता है।
आज तक डेट था मेरे
निकालिए इसका स्टेटस। सेकेंड अपील नंबर 521 ऑफ 1991 पटना ऑफ 91 पटना। आठ दो 22 का ना? इसके बाद 2025 का कुछ फाइलिंग है इसमें?
21-25 का एक फाइलिंग है।
तो डिस्पोजल केस में कैसे फाइलिंग लेता है? पता करिए भाई, डिस्पोजल केस में फाइलिंग, दो केसेस में फाइलिंग नहीं लेना चाहिए, डिस्पोजल केस में, एक सीएबी केस में। सीएबी केस में
झारखंड टाइप ऑफ रूल्स है कि सीएबी फाइल हो, कोई मॉडिफिकेशन
फाइलिंग कैसे ले लेगा? कोई भी तरह का फाइलिंग
नहीं तो
नहीं हो सकता डिस्पोजल केस में फाइलिंग। ठीक है, देखिए CMP number 76 of 2026।
अपडेट नहीं रहता है कभी कभी, उनको पता नहीं चलता, इसलिए एक्सेप्ट नहीं कर लेता है।
इसका मतलब ये अपडेट तो हमारी तरफ से, बेंच की तरफ से होता है ना, कोई भी चीज का अपडेट। ऑफिस मतलब हमारा बेंच ऑफ नहीं, हमारे यहाँ से रोज प्रोग्रेस जाता है, कैसे बोलते हैं आप? नहीं, डिस्पोजल का प्रोग्रेस तो बेंच से जाता है, वो अलग बात है। प्रीएम्प्टिव ऑर्डर इज अनदर थिंग। अदरवाइज अगर कोर्ट के ऑर्डर से कोई चीज डिसमिस हुआ है या कुछ हुआ है तब बेंच से होता है। Issue notice to the respondents both in the main petition and also in IA number 1121 of 2026, for which requisites be filed through ordinary process and also through speed post. सब देख रहे हैं?
Yes.
And also through speed post within a period of 15 days only. Preemptive 15 दिन में सारा नोटिस फाइल कर दिया, आईए में भी और मेन पिटीशन में। देखिए बहुत करेक्शन है पार्टी पोजीशन में, चेक कर लीजिए। पोस्ट ऑन 10th of April।
Under heading for admission, item 28, WPC 4584 of 2024.
क्या मैटर है?
This is for quashing annexure 4, by which as against the resolution of the government that the petitioner's claim and application was rejected without stating any ground, and on the other hand, of respondent number 4 by the impugned order was selected and granted the dealership, PDS dealership. Now, according to the resolution of the government, we have annexed annexure 5. This may kindly be seen in the supplementary, जिसमें कहता है कि the dealership will be granted only to those who have acquired grade 2. Annexure 5 में ये पैरा 3 का है। Now, respondent number 4 who has been granted, उसको कोई ग्रेड ही नहीं है, 3 महीना पहले वो काम शुरू किए हैं। कोई ग्रेड 1 भी उनको मिला है जिसमें annexure 3 हम लोग लगाए हैं, वो इम्प्यूट ऑर्डर के 3 महीने के बाद उनको ग्रेड 1 मिल रहा है, और हम आज 3 साल से हुजूर काम कर रहे हैं और ग्रेड 2 है मेरा, जो हम दिखा रहे हैं माय लॉर्ड, which is at page 26, will show that the petitioner's group has acquired grade 2, page 26. एलिजिबल भी वो रिस्पोंडेंट नंबर 4 नहीं है, फिर भी उसको दे दिया गया। पेज 26 में काइंडली रिसीव ग्रेड 2 जिसको मिला है 11-12 में, उसमें एक हम भी हैं फैंसी, ये सबसे नीचे नोट कॉलम में, फैंसी सेल्फ हेल्प ग्रुप, petitioner is fancy self-help group, or annexure 3 will show that the respondent number 4 was not even did not acquire even grade 1.
You were not qualified.
Actually, I was qualified for grade 1. However, I would like to bring the lordship's attention to the notification, supplementary affidavit notification. To the point that has been pointed out, that was only a proposal. The next page deals with what has been decided, 8.6. बजट के आरोप में विभाग का सुविचारित निम्नलिखित प्रस्ताव है. In this, nowhere it has been mentioned anything about grade 1 or grade 2.
The decision is here.
No mentioning about grade 1 or grade 2.
प्रस्ताव पर विचार किया है. This was a proposal, but it did not culminate into a decision.
Point 6 is what has been decided. And it's sure it is written, भविष्य में नया दुकान केवल द्वितीय महिला स्वयं सहायता समूह को ही आवंटित किया जाएगा.
क्या बोलना है सर?
Lord, I am more even then, Lord.
And even
For the
then,
last 3 years I have been working this group.
that वो तो दूसरा बात है. Yes, what do you have to say, Steve?
Supplementary contract filed on 2/7/2015, case number 6, 5, case number 5 para A. इसमें हम आपसे mention किया है कि petitioner किस विलेज के लिए अप्लाई किया है, ये मेंशन नहीं है.
They mentioned that. This is wrong.
ये भी है.
This statement, Lord, is an error of application action 1 will show.
All the three candidates.
लखी नारायणपुर के लिए अवेलेबिलिटी था और ये उसका नारायणपुर के लिए कुछ अप्लाई कर रहा है.
नहीं, annexure 1 देखा ना, मेरा application.
Respondent number 4 had applied for the village Lucky Narayan. Did you also apply for?
Yes. Annexure 1 page 10.
applied for Usman Nagar.
नहीं. Annexure 1 जो देखा जाएगा page 9. विषय में मृतक यासीन अली ग्राम लक्ष्मी नारायण से जन वितरण प्रणाली की दुकान का फैंसी स्वयं सहायता समूह के नाम से आवंटित करने की लक्ष्मी नारायण फूड के लिए the petitioner had applied. This is error of.
This also suffices that they have not been in possession of occupancy and profession since 3 years that they have claimed. Because in this application they are claiming the erstwhile shop owner has already died and hence same will be allotted to them. Secondly, this is only an application for allotment. The prescribed form is at the next page, watch it at page 10. In that page, point number 4, आवेदक के कारोबार के स्थान की अवस्थिति ग्राम कुष्मानगर.
Yes, serial number 4 में तो you have applied for which area, which place? You see, form is form ka. This is a prescribed form, right? In which, for which village have you applied should be reflected from the form, no? Not your letter.
This shows मिलॉर्ड कि वो कुष्मानगर में हम काम कर रहे हैं, लेकिन we have made application
आवेदक के कारवार के स्थान की अवस्थिति, yes,
कारवार की, तो उसी पंचायत में हम कुष्मानगर में हम काम कर रहे थे 3 साल से, उसी पंचायत में लक्ष्मी नारायणपुर में, तो हम जहाँ काम कर रहे हैं उसी का दे रहे हैं कि कारोबार कहाँ कर रहे हैं, ये उसके लिए लिखा हुआ है। Now the impugned order does not even speak one line, any reasoning for rejecting me. Not even one line. तीन साल से जो काम कर रहे हैं जिसको ग्रेड 2 मिल गया, by applying a dubious method and bias, they have given to a group which is hardly not even acquired a grade 1. Admittedly. कहीं भी इनका जो एप्लीकेशन इनवाइट हुआ उसमें कहीं नहीं है कि वो लक्ष्मी नगर का ही होना होगा, उसको लक्ष्मी नारायणपुर, और उसी पंचायत में हम तारानगर में
These cannot be a ground that you are working for 3 years, so some preference has to be given. Is there any provision that the preference has to be given to a person who has been working for 3 years? ऐसा कुछ नहीं है. Your entire writ petition was based on the ground that there is a violation of the circular. So now you demonstrate that there is a violation of the circular. You see, we have very limited jurisdiction so far as these aspects are concerned. We are seeing everything.
3 साल से जो काम कर रही हैं ग्रुप,
अरे भाई 3 साल से जो काम कर रही है इसका मतलब ये नहीं है कि वो बहुत अच्छे हैं.
तो ये भी तो कहीं लिखा जाएगा ना.
कोई बात नहीं. आपने
रिजेक्ट कर रहे हैं उधर एक लाइन
writ petition, you see, they have to choose a person, right? You have filed a writ petition on the premise that there has been a violation of the circular. Now you demonstrate that there has been a violation of the circular.
Violation तो वो
है नहीं. आपका तो पूरा writ petition इसी पे बना हुआ है, right?
Your lordship have held note that reasonableness, the fairness. यहाँ पर देखा जाएगा उधर 3 साल से जो लोग काम कर रहे हैं उसी पंचायत में, has been ignored completely. It's a case of bias, arbitrariness, of course subject to my lord's consideration always. But this is what I would like to drive home to this honorable court. Lord, it's wholly arbitrary.
We will see that. Yes.
Case number 50
50
1
of the writ petition. One 5 years.
जिला पाकुड़ और पंचायत तारानगर, सीरियल 5 1 में लक्ष्मी नारायणपुर और 2 में तारानगर, यही दोनों जिला.
तारानगर पंचायत में तो हम हैं ही.
आप तारानगर पंचायत में?
जी हाँ.
उसमें भी 2 पार्ट है, एक लक्ष्मी नारायणपुर का है और एक तारानगर का है. You are a resident of Taranagar.
तारानगर और उसी में लक्ष्मी नारायण.
That's right. नहीं. You are a resident of Taranagar, but this particular allocation has been made for Lakshmi Narayanpur.
और कुष्मानगर में हम 3 साल से वहाँ पर कारोबार चला रहे हैं.
कुष्मानगर बोल के तो कोई जगह ही नहीं है यहाँ पर. इस लिस्ट में तो नहीं है.
नहीं, मेरे इसमें अभी जो फॉर्म देखा गया मैडम, उस फॉर्म में हम लोग से पूछा गया कि कारोबार कहाँ करते हैं. तो उसमें कुष्मा नगर आया, तो कुष्मा नगर जहाँ कर रहे हैं वो तारा नगर पंचायत में ही है।
और आप
हम उसी पंचायत में,
नहीं, आप लक्की नारायणपुर के लिए लड़ रहे हैं ना?
जी हाँ, और लक्की नारायणपुर तारा नगर पंचायत में।
क्या चीज?
आर्बिट्रेरी तो नहीं हो। और इनका एनेक्सर 4 भी देखा जाए, नो does not spell even one line as against as to why I am being rejected. चार लाइन का ऑर्डर उनको एनेक्सर 4 पेज 31 में।
ये तो जिनको एलोकेशन किया गया है उसका है ना, ये एलोकेशन लिस्ट है। दिस इज नॉट रिजेक्शन ऑर्डर, दिस इज एलोकेशन लिस्ट।
रिजेक्शन ऑर्डर उस तरह से हम लोग को मिला नहीं, कहीं कोई ऑर्डर नहीं हुआ, एलोकेशन बस हो गया। और मेरा कहीं इसमें कि क्यों हमको रिजेक्ट करने कैंडिडेट्स हैं, more fully arbitrary on the very face of it. तीन साल से उसी पंचायत में कुष्मा नगर में हम लोग उसमें इन्वेस्ट करके गवर्नमेंट से भी हमको हेल्प मिल रहा है।
नहीं, 3 साल से जो आप काम कर रहे हैं तो उसका क्या डॉक्यूमेंट है कि आप 3 साल से काम कर रहे हैं? Where is that document?
ग्रेड 2 मतलब वही हुआ।
I do not know grade 2 का क्या होता है।
3 साल हम लोग लिख कर दिए, नॉट डिनाइड।
3 साल से कहाँ, कोई तो गवर्नमेंट ने आपको दिया होगा ना डॉक्यूमेंट?
हाँ दिया।
Where is that?
पेज 26 पर ये देखा जाए जो ग्रेड 2 हमको दिया जा रहा है, ये डीडीसी का ऑर्डर है। इसमें है कि स्वर्ण जयंती ग्राम स्वरोजगार योजना अंतर्गत प्रखंड विकास पदाधिकारी पाकुड़ द्वारा प्राप्त प्रस्ताव के आलोक में निम्नांकित 2 स्वयं सहायता समूह सेल्फ हेल्प ग्रुप का प्रथम ग्रेडिंग के पश्चात वित्तीय वर्ष 11-12 में द्वितीय ग्रेडिंग किया गया है, तदनुसार तैयार परियोजना प्रस्ताव की स्वीकृति दी जाती है। और इसमें उधर हमको कॉलम 2 में फैंसी सेल्फ हेल्प ग्रुप, दिस इज द petition.
So you were working in Taranagar, right?
In the Taranagar Panchayat at Kushmanagar.
At Kushmanagar, correct?
Mine. और इनको कोई ग्रेड नहीं है, एक ग्रेड तक 3 महीना, और हम लोग बोले हैं पैरा 7 में नॉट डिनाइड कि 3 महीना पहले एप्लीकेशन के ये 3 महीना से ही काम शुरू ही किए। और एनेक्सर 3 देखा जाएगा कि जिस दिन ऑर्डर इनको हुआ इनके फेवर में, उसके 3 महीने के बाद इनको ग्रेड 1 मिला है। वो एनेक्सर 3 विल शो नोट एनेक्सर 3 at page 30 में kindly receive now. पेज 30 पर उसी तरह से इनके बारे में कॉलम 4 में फकीरा है मेरा रिस्पॉन्डेंट नंबर 4, इसको दिया गया है प्रथम ग्रेडिंग, सेकंड लाइन ऊपर से माइनर प्रथम ग्रेडिंग के
फकीरा कहाँ है? अच्छा सीरियल नंबर 4
में। तो इवन फर्स्ट ग्रेडिंग भी नहीं था।
You belong to which village? Village का नाम बताइए, अपने विलेज का नाम बताइए।
कुष्मा नगर मिला, और पंचायत हो गया तारानगर। और लकी नारायणपुर भी तारानगर पंचायत में।
और लोकेशन कहाँ है शॉप का?
The one which is challenge, that is at Lucky Narayan.
लकी नारायण।
So there was no
This
reason
Lucky
to,
Narayanpur is the village. The location of the shop is also in the village. And it is Panchayat Taran. We heard the learned counsel appearing on behalf of the petitioner. This writ petition has been filed for the following relief.
I was not even asked कि लक्ष्मी नारायणपुर में आप कर पाइएगा।
The learned counsel for the petitioner has submitted that the petitioner is a resident of village Kushmanagar in Panchayat Taranagar and had applied for allocation of shop under public distribution system for village Lucky Narayanpur.
In the same point.
Falling in the same panchayat. He submits that no reason has been assigned to the petitioner for not declaring the petitioner successful, and on the other hand, it has been provided the shop under public distribution system has been allocated to the private respondent number 4 in for the village Lakshmi Narayan. The learned counsel has also submitted that the petitioner has the petitioner has been labelled as grade 2 as the petitioner has been and accordingly the petitioner is a much better candidate than the private respondent. The learned counsel has also submitted that the private respondent that the respondent authority have violated the terms and conditions of allocation of shop, and such terms and conditions have been not the terms and conditions have been allocated in violation of the circular dated 6/8/2009, which has been placed on record by filing a supplementary affidavit. He submits that the shop was to be allocated only for BPL ladies and self-help group who have already achieved grade 2. The Learned Counsel has submitted that the allocation of shop is arbitrary and therefore the relief as prayed for be granted to the petitioner. The Learned Counsel, appearing on behalf of the private respondent, has submitted that as per the circular dated 6/8/2009, it was only a proposal that only BPL ladies and self-help group falling under grade 2 would be entitled for the license, but the proposal did not culminate in a decision, as the decision is contained in paragraph 6 of the circular. He submits that there has been no violation of the circular as alleged by the petitioner. In addition to the aforesaid submission, the Learned Counsel for the state has also referred to the supplementary counter affidavit, which at page 15, and has submitted that in Panchayat Taranagar there were 2 vacancies, one for Lakhinarayanpur and other was Taranagar. The private respondent number 4 is a resident of Lakhinarayanpur, where the shop has been allocated. He has got all the basic requirements in the village Lakhinarayanpur, and so far as the petitioner is concerned, admittedly the petitioner is not a resident of the village Lakhinarayanpur. The Learned Counsel submits that since there is no violation of the circular and the petitioner being admittedly not a resident of village Lakhinarayanpur, therefore the writ petition is devoid of any merits. After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, it is not in dispute that the petitioner is not a resident of Lakhinarayanpur and the application filed by the petitioner also reveals that the petitioner is a resident of village Kushinagar, though falling in the same panchayat, that is Taranagar, Kushmanagar. Though falling in the same panchayat, that is Taranagar, in which Lakshmi Narayanpur village is also located. The place of business of the petitioner has also been shown in Mauza Kushma Nagar. Admittedly, the allocation of shop in the present case is related to village Lakshmi Narayan. So far as the allocation, so far as the violation of the allegation regarding violation of the circular dated 6/8/2009 is concerned, the paragraph 3 thereof, which provides that the shop will be allocated only to BPL ladies and to self-help group who have achieved grade 2, appears to be only a proposal, and ultimately the decision is contained in paragraph 6, which does not contain any such clause. And therefore, the petitioner has not been able to demonstrate that there has been any violation of the circular dated 6/8/2009, within bracket annexure 5, placed on record by way of supplementary affidavit. This court is of the considered view that the petitioner has not been able to demonstrate any serious illegality or violation of the circular dealing with the allocation of shop in the instant case. Accordingly, this court is not inclined to grant the relief as prayed for by the petitioner. Consequently, this petition is hereby dismissed.
Item 29, Civil Review 94 of 2023.
Thank you. Highly matter relates to restoration of land lawsuit. The private school filed an application for restoration of land which was allowed, against which lawsuit filed appeal in division, which was also dismissed, against which lawsuit petition was filed, and there was order of this honorable court that no document was filed for mutation lawsuit. That document was not available lawsuit. Therefore, lawsuit filed in LPA and received a copy of the mutation lawsuit, and liberty has been given by this honorable court to file civil review before this honorable court lawsuit.
Where is the order by which
Honorable division में
order कहाँ? Order?
order of the honorable division से
हाँ?
इसमें next claim के फाइल नहीं है उनको
ऑर्डर है लिबर्टी मिला है तो सिविल रिव्यू फाइल
ऑर्डर लगाए नहीं है
Letter 9/74.
Page 74.
74.
The LPA is not pressed. तो इसमें कहाँ है आपको कि ये डॉक्यूमेंट
लेटर काउंसिल अपेयरिंग जहां द ऑफेंस लीव ऑफ दिस कोर्ट टू बी सफिशिएंट टू फाइल विथ
सो
एज टू फाइल विथ
रिव्यू कैसे जो चीज आपका रिकॉर्ड पर नहीं है अब उसका बेसिस पे हम यहाँ पे कहाँ रिव्यू करेंगे
ये तो
आ गया है तो भी क्या करेंगे उससे आ गया नहीं नहीं सबका कुछ मतलब ही नहीं है
नेक्स्ट वीक कुछ हम जजमेंट भी लाएंगे इसमें इससे रिलेटेड जजमेंट
नहीं कोई रिलेटेड
एक
जजमेंट
दिन सुना को रख दिया है सुना को एक दिन का बोल रहे हैं एक दिन के लिए जितना है हमारे फेवर में कोटेशन को ऑर्डर लगा दिया
उससे नहीं होगा ना
अवेलेबल नहीं था
अरे आप समझ नहीं रहे ये तो टाइटल सूट यहाँ थोड़ी हम डिसाइड कर रहे हैं
टाइटल सूट नहीं है but there was observation of the Supreme Court like no document was filed with respect
why did you file it why did you not file it
that time of it is not available also
not available
I will assist
म्यूटेशन बाद में कराए हैं
नहीं पहले ही है
तो क्यों नहीं अवेलेबल था आपके पास
उसमें मिला नहीं हम लोग को घर
मिला कैसे नहीं मिलेगा आपको
नहीं मिला इसलिए हम लोग लगाए नहीं
नहीं ये कोई रीजन नहीं है दिस इज नॉट अ ग्राउंड फॉर रिव्यू
ठीक है अगर सपोज
ये नीड ऑफ एडॉप्शन भी लगाए हुए हैं इसमें
हम देख लेंगे क्योंकि ये बढ़िया से इसको देख नहीं पाएंगे
एडॉप्शन का भी कहानी हम रीड पिटीशन
नहीं नहीं तो
सही
लगाएंगे
करेंगे
नहीं उसको तो हम करेंगे
लगाए तो हुए
हम
हैं
देख लेते हैं तो हम इसको देख नहीं पाए नेक्स्ट
इतना सारा डॉक्यूमेंट लगा दिए हैं अब ये सब डॉक्यूमेंट बैठ के डिसाइड करेंगे आपका टाइटल सूट
नेक्स्ट वीक
Civil Review number 94 of 2023. Counsel for the petitioner seeks adjournment. He submits that this review petition has been filed pursuant to order passed in LPA number 765 of 2019. Post on Wednesday supplementary was listed. होगा लेकिन 2:15 ही बजे जी पिटीशन सब 2:15 बजे
जी 2:15 की टाइम दीजिए
आई 2:50
Item 40 CRMP 1918 of 2025. Item 30 FA 229 of 2025.
Yes, किस हेडिंग में है ये?
ये admission है.
FA 4487 of 25 admit. Call for the records from the concerned court.
There are two private parties.
Let notice be issued to respond number National Highway Authority Content.
Separate.
Issued to respond number 4 to 6, for which requisite under ordinary process and speed post be filed within a period of 1 week. The respondent number 2, 3, 1, 2 and 3 is already represented by the learned counsel for the state. So no notice need be issued. Since the counsel for the appellant is absent, let this order be communicated. Let soft copy of this order be communicated to the counsel to ensure compliance. Let this order be communicated to fax को तो बोली थी, ठीक है? Next date would be 7th April.
Item 40 CRNT 1918 of 2025.
That is the status report has come. And as per the status report, the date was fixed on 31st of October 2025 for recording statement of the accused, that is petitioner here, under section 1316.
What is this
Yes,
CRNT for?
this is the restoration, due to non-removable defect of criminal division number 70 of 2024.
What was the revision for?
Yes, the reason was for, that is the, against the, that is the 3/3/2000, the order dated 3/3/2023 passed in criminal division number 78 of 2024, whereby the
You see, this petition has been disposed of earlier.
earlier, this is the second restoration application.
This is not maintainable.
Because of the
How the
reason,
second restoration is maintainable?
because of the reason law, earlier my lord has granted me time to remove the defect. All the defects were removed, law, and it was told to the reason law that all the defects have been removed. Thereafter, only 17 copy was required.
No, you see, once you file an application for restoration, and if you do not comply with that order, and the revision is dismissed, you will file another application for revision for restoration. You have to take steps in the CRNP only. What is this?
This is the CRP.
No, CRNP for modification of this order for extension of time granted in CRNP number 3381 of 2024. एक बार DFD हो जाएगा, फिर उसके बाद दोबारा DFD हो जाएगा, कितना बार हम लोग रेस्टोर करेंगे? नहीं हो सकता। काफी है ना? नहीं, second application for restoration of the revision petition is not implemented. How is the second application been done?
Then I will be liberty to file the modification of the order.
Yes, you can seek extension of time in the earlier order only.
Yes. That time. Appropriate application. For extension of the time for renewal.
CRMP number 1918 of 25. This petition has been filed for restoration of criminal revision number 78 of 2024, which was dismissed on 17/1/2025 on account of non-removal of defects. Thereafter, the petitioner had filed another petition. File a petition being CRMP number which was dismissed on account of non-removal of defects in terms of order dated 3rd of July 2024. Thereafter, the petitioner had filed a petition for restoration being CRNP number 3381 of 2024, which was whereby the time was extended for removal of defects by order dated 20/12/2024. In spite of that, the defects were not removed. And now the petitioner has filed another petition for restoration of the criminal revision. This court is of the view that the counsel for the petitioner is not in a position to explain as to how the second application for restoration is maintainable. And this counsel for the petitioner seeks permission to withdraw this petition to take appropriate steps in connection with order dated 20/12/24 in CRMP number 3381 of 24. liberty is granted. This CRMP 1918 or 25 is dismissed.
साइन कर देंगे
इसमें साइन कर दो.
Item 41 CRMP 3478 of 2025.
This is filed for the restoration of CRMP 2535. It was filed for the restoration of criminal record. Basically, this is the second restoration. Arguing for the time we granted to remove the difference.
CRMP number 3478 of 25. This petition has been filed for restoration of CRMP number 2535 of 25, which was disposed of by the order dated 26/9/25, whereby the order dated 26/9/25 passed in criminal revision number 1638 of 23 was modified by extending the time for removal of defects. The learned counsel for the petitioner has submitted that, in spite of order dated 26/9/25, the defects could not be removed. You have deposited 10,000 rupees
I have filed the proof that is
and has submitted that rupees 10,000 in terms of that order has already been deposited. She submits that further time be granted to remove the defect. Considering the submissions, the time granted by the order dated 26/9/2025 in CRMP number 2535 of 2025, extending the period of removal of defect in criminal revision number 1638 of 2023 till 10/10/2025 is now extended till
20 to 26.
is now extended further till 20/2/26. If the defects in the criminal revision is removed in terms of the modified order, in terms of the present order, office is directed to place the criminal revision before appropriate bench as per roster. CRMP number 3487 of 25 is hereby disposed of. What is the surviving defect? Surrender certificate?
No, there are two minor differences. With regard to the
Item 42 CRMP 3524 of 2025.
Restoration of the criminal division 118 which stood dismissed for non-compliance of the ordinance of the 13/6/2024. So certain defects were there required to be cured. Half of them were cured, but there are certain illegible copy which cannot be read out numbers, and thereafter due to 2 weeks time period that cannot be procured by the certificate copy. As a result of which remaining part of the defect were not stand.
What was the remaining defect?
First, 3-4 pages were there which were required. Half of them were filed, but there are certain pages which are required to be filed. But the documents which are available with us is not there.
Where is the order of dismissal?
It was bulk order. It was a bulk order.
हर एक केस ना अलग अलग कॉल करके order. Every case is called separately. The order is drawn.
Yes, yes, no. Every case was called separately, but order was.
It is always like
Yes,
that.
yes, no.
Bulk order
No,
not
no.
yes.
It was called separately, but order was.
क्या क्या डिफेक्ट है?
Time copy.
Surrender certificate.
Sorry, no.
Surrender certificate.
Surrender certificate. Check the defects है.
because those defects were, I have also mentioned in that paragraph that half of them were being filed.
सरेंडर सर्टिफिकेट का रिक्वायरमेंट है कि नहीं?
नहीं, surrender certificate
नहीं।
I have to cross check this.
नहीं चेक करिए तो सरेंडर सर्टिफिकेट का डिफेक्ट है।
There was a distress order notice and subsequently filed a CIMP environmentally before this honorable court and liberty was granted thereafter event before local court violation 126 of this year. Wherein an order was there and thereafter a criminal application, miscellaneous application was being filed which stood rejected after being refused representation due to non-compliance.
है क्या कोई सरेंडर सर्टिफिकेट? सरेंडर सर्टिफिकेट इस क्या आप कन्विक्शन के अगेंस्ट आए हैं? Is the revision filed against conviction?
No, it was 125.
120.
Yes.
मेंटेनेंस का ऑर्डर चैलेंज किया हुआ है यहाँ पे।
नहीं, 125. I have filed a CIMP inadvertently, and thereafter this honorable court directed a liberty. Thereafter the petitioner went before.
रिविजन में impugned ऑर्डर क्या है?
रिवीजन में impugned order है प्लस 126(2) के अंदर में criminal miscellaneous application against 125 फाइल किया. Subsequently that order was set, and to that has been challenged by way of 126. The order was challenged, and that stood rejected for non-prosecution. That order was challenged before this criminal revision. The criminal revision stood dismissed for non-compliance, and this CIMP for resolution.
The case CRMP number 3524 of 2025. This petition has been filed for restoration of criminal revision number 118 of 2023, which was dismissed due to non-removal of defects in terms of order dated 13/6/2024. The learned counsel submits that due to inadvertence, the defects could not be removed. Order of 125 must have been passed, no?
Yes.
So you are compliant with that? No.
Because that order was passed ex parte. Thereafter, this 126 application was made.
You are for the state?
Yes.
You are ready to otherwise cooperate with the proceedings?
Yes.
Then I should issue notice to OP number 2. दोनों के पेरेंट्स का ऑर्डर डेट फिक्स कर देंगे, उनका भी पर्पस सॉल्व हो जाएगा, ठीक है ना? ये प्रोसीडिंग इधर उधर करके क्या हो? Right? Try to figure it out.
Yes.
Let notice be issued to the opposite party number 2, for which requisites through the concerned police station, for which requisites be filed within a period of 1 week. Post on 27th. ठीक है? आप हैं क्या इसमें? 41. ये कौन सा नंबर चल रहा है?
41 restore and ये चल रहा है 42 का
41 restore.
Item 43 CRMP 3595 of 2025.
Yes, petitioner. ये क्या है आपका?
CRMP 3595.
Yes. What is this?
filed only because of the reason that some development has been thought of and the settlement has been made before the learned court below in maintenance case, that is annexure 3C, wherein one-time settlement has been made. And in this settlement, it is part 18, but it is also indicated that the bail draft of rupees 3 lakh will be handed over to the petitioner by the opposite party in criminal division between the parties of this case pending before the High Court.
तो इसमें ओपी नंबर को तो पार्टी नहीं बनाया है, कहाँ बनाया है? इसमें कहाँ पार्टी बनाया है? रिविजन में देखिए तो पार्टी है कि नहीं? आपका सरेंडर सर्टिफिकेट का डिफेक्ट है ना?
सरेंडर सर्टिफिकेट
जब तक वो डिफेक्ट नहीं रिमूव करेंगे ना, हम आपका रिविजन नहीं रेस्टोर करेंगे।
वन टाइम सेटलमेंट
कुछ भी हो गया, वी डोंट बॉदर अबाउट। जेलिंग तो क्या होगा? डॉक्टर है जेल में, उसका आप चिंता मत करिए। क्रिमिनल केस का कंपाउंडिंग हो गया है, क्रिमिनल केस का कंपाउंडिंग हो गया है। वन टाइम सेटलमेंट इज अनदर थिंग, क्रिमिनल केस का कंपाउंडिंग इज अनदर थिंग, बोथ आर नॉट वन एंड द सेम। यू कैन सेटल योर मैट्रिमोनियल डिस्प्यूट, क्या किसमें आपका कन्विक्शन?
490।
सरेंडर तो करना पड़ेगा, सोच समझ के आइए, बिना सरेंडर किए आई विल नॉट कन्विक्ट। क्या मिस्टर पंकज ठीक बोल रहे हैं ना? सरेंडर तो करना पड़ेगा। एग्जेम्पशन कोई एग्जेम्पशन नहीं देंगे, ये ऑर्डर है, इसका कंप्लायंस करिए। दैट वाज अ डिफेक्ट इन द पिटीशन, हम खाली डिफेक्ट रिमूव करने का एक्सटेंशन दे सकते हैं 10 दिन, सरेंडर तो करना पड़ेगा, फिर से डिस्कस हो जाएगा केस। बिना सरेंडर किए नहीं होगा, नॉट पॉसिबल। I will extend the time for वो अभी कर देते।
हम मेडिकल भी लगाए हुए।
उससे क्या हो गया?
ठीक है, और उसका टाइम दे बोल दें।
CRMP number 3595 of 2025. This petition has been filed for restoration of criminal revision number 401 of 2023, which to dismissed for default on account of non-compliance of order dated 22/6/2024. The learned counsel for the petitioner has submitted that the defects could not be removed within time. And in the meantime, there has been a joint compromise in the matrimonial matter. The revision was filed challenging the order of conviction under section 498A of the Indian Penal Code. Considering the fact the time for removal of defect as granted by the order dated 22nd of June 2024 is extended till मार्च तक रखते हैं और 12 मार्च तक आपको टाइम देते हैं। आप 13 तारीख को केस लगा देते हैं, हम रेस्टोर कर देंगे। आप डिफेक्ट रिमूव करिए, हम रेस्टोर कर देंगे और ऑर्डर भी कर देंगे रिवीजन में लिस्ट करने में। क्या चीज का आइए CMP में कुछ नहीं फाइल करेंगे, आपका रिवीजन रेस्टोर हो जाएगा, रिवीजन बेस कर लेंगे, हो गया बात, यही होगा। कन्विक्शन कंपाउंड नहीं हुआ है, मैट्रिमोनियल डिस्प्यूट कंपाउंड हुआ है।
Settlement has been made in entire matrimonial because 12 lakh
498A is a matrimonial dispute.
because division pending
कुछ
है।
लॉ दिखाइए। फिलहाल तो हम ऑर्डर कर दिए, इस ऑर्डर को ही आप चाहें तो चैलेंज कर लीजिए आप। हम नहीं ऐसा परमिट करेंगे। सरेंडर तो आपको करना पड़ेगा।
Surrender तो करना ही पड़ेगा।
2023 से मैटर को इस तरह से पेंडिंग छोड़ के, ऑर्डर का कंप्लायंस नहीं करके, कोर्ट का टाइम वेस्ट करके, सरेंडर तो करना पड़ेगा। आप बता दीजिए कब तक सरेंडर सर्टिफिकेट फाइल करेंगे जिससे कम से कम आपको जेल में रहना।
कॉन्टैक्ट किया जाए तो पूरा बीमार चल रहा है।
बीमार तो जेल के नाम से कोई भी बीमार हो जाएगा, उससे क्या?
67 years old है, एजिंग पर्सन है, मेडिकल लगाया है।
उससे क्या होगा? We'll give you all the medical assistance in the jail. सारा असिस्टेंस का ऑर्डर भी कर देंगे। एग्जेम्पशन का तो पिटीशन ही नहीं फाइल किया। नहीं करेंगे हम ऐसे। ठीक है। नहीं करेंगे।
नोटिस कम से कम कर
11 मार्च तक आप फाइल कर दीजिए अपना सरेंडर सर्टिफिकेट। मतलब for removal of defects है till 11th of March. Post on 13th. नहीं एक सेकंड, ऐसा पेंडिंग नहीं रहेगा। If the defects are removed within the extended time, office is directed to place the case before appropriate bench as per roster. तो रिवीजन में ही फाइल होगा सरेंडर सर्टिफिकेट, यहाँ नहीं फाइल होगा इस केस में। CRMP डिस्प्यूट।
Item 44 CRMP 366 of 366 of 2025.
This is for restoration of criminal division number 879 of 2023. It was dismissed for non-compliance of order dated 22/6/2025. There were three. First of all, this is a criminal division we have filed against the conviction in NI Act. They have settled the matter before filing of the criminal division. However, there were three defects. One was for the delay, other was for the surrender certificate, and in one more defect, dates were mismatching in the judgment. For that, I had filed an IA for the ignorance of the for removing that defect, but it could not be disposed of, and hence the case was ultimately
You might not have appeared on that day. You might not have appeared on that day.
I accept it.
So, I give you the time to extend to remove the defects.
I have already filed an IA for that. As far as the surrender certificate is concerned, the petitioner is in custody, already in custody.
He's already in custody.
Yes.
Where is the surrender certificate?
It is not in the petition. Just procured.
Okay, that's right. Then I will extend the time for removal of defects. You file it then. How much time do you need?
1 week.
1 week. CRMP number 3663 of 25. This petition has been filed for restoration of criminal revision number 879 of 2023, which has been dismissed on account of non-removal of defects in terms of order dated 22/6/2024. The learned counsel for the petitioner has submitted that the petitioner has already surrendered, and the remaining defects will also be removed. He has also submitted that one IA was also pending in connection with the defect. Considering the submissions, the time for removal of defects in criminal revision number 879 of 2023 is extended till, just tell me, what date do you want? Till 11th of February. If the defects are removed within the extended time, office is directed to place this case before appropriate bench as per roster at the earliest.
Item 47 first appeal 3 of 2026.
admit, call for records from the concerned court. The respondents are the authorities of the state who are to be represented by the Office of Learned Advocate General. Since nobody is appearing on behalf of the respondents, let a copy of this order be forwarded to the Office of Learned Advocate General to ensure appearance of the counsel. Close this case on. March.
Item 48, CMP 7 of 2026.
Yes, discussion of case number given and some tickets were removed and regarding type of
CMP number 7 of 2026. This petition has been filed for restoration of WPS number 3194 of 2020, which stood dismissed on account of non-removal of defects in terms of order dated 6/5/2022. Nobody appears on behalf of the respondents. Counsel for the petitioner has submitted that on account of inadvertence, some of the defects could not be removed. Considering the submissions, the time for removal of defects granted by the order dated 6/5/2022 in the writ petition is extended till 27th February. If the defect in the writ petition is removed within the extended time, office is directed to place the writ petition before appropriate date as per roster. This CMP is accordingly disposed of.
Item 49, CMP 17 of 2026.
Restoration of
double case number 4 defects were not, it is the type copy which will be filed within a few days. So 1 week.
same order per division. This is in connection with WPS number 4133 of 2024.
23.
Of 2023, or preemptory order is dated 13/5/24. Respondent absent. Restored privileges. Next.
Appearance.
Give your appearance, please.
Item 50, CMP 35 of 2026.
Restoration
Of
WPS case number 2398. This is for reporting from non-removal defects within that.
same order by the counsel for the state is present. Any objection?
Counsel JPSC.
Counsel for responding JPSC is present. Nobody appears on behalf of the state. Right. Restored privileges. Same order privileges. Next.
Excuse me, sir. Item 51, CMP 41 of 2026.
FA.
The only surviving element was related to maintaining the duties. That was the only reason it was dismissed. On the other just
Why was it not maintainable? Yes?
as per the
You have to file an IA, whatever you have to say through one. Right?
I
Yes, we do not know what was the issue about. Why was it not maintainable? The case CMP number 441 of 2026. This petition has been filed for restoration of FA filing number 13011 of 25, which stood dismissed on account of non-removal of defects in terms of order dated 21/11/2025. The learned counsel for the petition has submitted that there was certain technical defect and we shall take appropriate steps in the first appeal if it is restored so that the defect can be taken care of. Nobody appears on behalf of the respondents to oppose the prayer. However, considering the submissions, the time granted to the appellant in FN filing number 13011 of 2025 for removal of defects by order dated 21/11/2025 or to file an appropriate is तो already उसमें that you can file an appropriate petition in connection with that. In terms of order dated 21/11/2025 is extended till 27 till 27. If the petitioner acts in terms of order dated terms of order dated 21, if the needful has been done, is done within the extended time, office is directed to place the first appeal before appropriate bench as per roster under appropriate.